It's not in the definitions. It might be like right up here. It's just a set of words that the index calls 93, actually.
It's at the top, there's like the little sparkle emoji, that's the AI.
Oh, okay, and it's still recording.
So it's probably one of these definitions.
Yeah, there.
Yep, that's where it is. So it is a minor subdivision. So back to table 4.1. Do you have a copy of these?
I don't have a printed out copy. I've seen them read on good enough, but I haven't a printed copy.
Okay, good. All right, so
Yeah, we do.
essentially the same, whatever the,
I've been on this for a long time. I still don't
yes.
know them by heart. I use my workplace software to print that thing out. Binder it up.
Yeah, okay, so back to the agenda. Do we have minutes to approve? And
Yeah. They should be.
I think I did them out right after the meeting
Mhm.
last time, yeah. It wasn't from last week, right? It was early April, yeah. I saw them.
Within 5 weeks of them.
are you able or willing to make a
Yeah, I
motion?
accept those minutes. I didn't.
All right, we have a motion to accept the minutes. Is there any discussion? Any changes to those minutes? Recommended?
No.
Okay. We have a quorum. All in favor of approving the minutes as presented by the secretary, please say aye. Aye. Opposed, say nay. Any abstentions? Okay. And then we can go right to the DRB procedures and Vermont open meeting law training. We have Ms. Emily Cloft of the Northwest Regional Planning Commission. Does everybody know Emily? I get to see her quite frequently.
Yes,
Yeah. You meet out.
yeah, I think I've met, everyone, I'm pretty sure. I was here, I think, like about a year ago doing a
Oh,
consultation.
yeah, that's right.
Yeah.
Yes, right.
Yeah, so I think I met most of you then, at least.
Thought we were gonna get you for the plan review.
I
Yeah,
know. Have to
Get a sign.
get everyone. Very nice, everyone. Thank you for all being willing to sit through the training today, and I'll kind of go through each section, and then if you have questions, you can stop me, or we'll stop at the end of each section as well.
Okay.
We're gonna be watching a show up here, right? Or there's gonna be some slides.
Yeah, I've got some slides. Can you see them now? I shared them on Zoom, so. Yeah, so the presentation tonight, I've got 4 broad sections: the board roles and responsibilities, an overview of what's in the zoning and subdivision regulations, how to make effective local land use decisions, the hearing process and decisions, and then a brief sort of abbreviated section on open meeting law. I will note that whoever ends up being the chair of the Development Review Board will be required to take the Secretary of State open meeting law training. The rest of the members are not required to take that, but the chair is. And that's a requirement for DRBs, ZBAs, and select boards.
Be helpful for other members to take that.
Yeah, it's online. It's the Secretary of State online training. I think it's like a 37-minute video, so it's pretty short. There are also other ones available that don't meet that legal requirement, but the VLCT has some training. We have some training as well, so there are lots of options. If for some reason you don't like that video, but yeah, Secretary of State one is totally fine.
Be better. Yeah.
It's all basically the same content, so. No. Yeah, so diving right into board roles and responsibilities. So as you probably remember from some sort of civics or US history class, at the federal level, we have the three branches of the government. We have the legislative, which is creating the judicial, which is interpreting the law, and the administrative, which is executive in the federal system, which is implementing the law through government. So it's somewhat similar at the local level, where you have the planning commission and the select board that are basically responsible for creating and adopting a zoning bylaw and a plan. The DRB, or in some cases the ZBA, performs that quasi judicial role. You're not a court, but you are interpreting and trying to apply the zoning bylaw as written. And then the select board and the staff, like the zoning administrator, then implement administrative review. And we also have in here interested persons who are individuals who have the right to participate in the hearing process and can appeal the decision of the board. And we'll go more into the interested persons as we talk about making effective decisions. Yeah, so as I noted, these are the different groups that can fit within town. So in Bakersfield, that's the Select Board and Planning Commission, and now you've moved to having a development review board rather than having that split zoning board of adjustment and planning commission model. Yep.
So relative to those
Yep.
4 categories, just trying to get a better sense of what the differences are. I mean, I know what legislative
Yep.
is relative to our legislature,
Mhm.
and that appears or makes me think of lawmaking.
Yep.
And so the planning commission, which we're going to continue to actually staff,
Yep.
would be the lawmaking,
Yes.
which is the bylaws.
Yep. Writing like the plan which informs the bylaws, but really, yeah, when you're thinking about like the law you're creating is the bylaws, the zoning bylaws. So in the process of writing and amending those, you're acting as a planning commission, basically setting the policy for the zoning bylaw. And then when you move into that, okay, we're now applying the bylaw as currently written and adopted and seeing if a specific project meets that bylaw, that's you acting in the development review board, that function, that quasi judicial role.
And then,
Yep.
and I understand judicial,
Yep.
but when you put the word quasi in
Yes.
front of it, it makes it seem like it's different.
Yeah, I mean, you're acting sort of like a court, but you're not exactly a court because you don't have the same sort of process set out. But it does act as part of that court system, whereas if they, dislike the decision of the development review board, it then goes to the environmental court. So
I think there's more, because I remember
Yeah.
being on the ZBA board, like
Yep.
you literally couldn't talk to anybody.
yeah, there are more.
You could not talk to even the appellants
Yep.
or each other
Hmm.
about,
the meeting.
yeah,
Hmm.
because you are considered a judge
Yep.
for that,
Yeah.
so.
Yeah, so when we go in more into the sort of process of the hearing and making decisions, we're the sort of, when you're the planning commission and you're doing broad planning and trying to write your zoning bylaws, you can act in a very informal manner. You can chat with people at the grocery store. You can, set a pop-up tent out in front of the park, and that's all fine because you're acting as a planning commission, you're doing your legislative function, you're building policy. But when you're operating as the development review board as it relates to a specific proposal, there are much stricter guidelines for how you act and how you run the process, because that hearing process it's not quite a court, but it requires that due process for the applicant and for the interested persons involved is upheld. So it becomes a much more regimented process that you're following.
And then the third the administrative,
Yep.
zoning administrator appears to be someone who is sort of actually taking care of the tasks of the development review board's decisions.
So, yeah, and well, we can get into the sort of different functions.
Okay, if
A little
you
bit
get
here.
to.
Yeah, I'll get to the different functions of each
Right.
group. So yeah, this is just a brief on the appointment. The select board is always elected. The planning commission, DRB and ZBR, are you appointed in Bakersfield or are you elected? Elected, yeah. So some towns appoint and some towns are elected. And then the zoning administrator is appointed by the select board.
I don't know if there's been a decision relative to the DRB.
So you're elected as
The
planning.
election,
This is appointment.
appointments?
Yep.
we have, as we were previously constituted
Mhm.
as a planning commission, been elected.
Yep.
The zoning board of adjustment,
Yep.
which is being dissolved,
Yes.
or replacement by the development review board,
Mhm.
is, I think, appointed. Is that correct? Were they appointed? I don't remember ever voting for.
I think you can be voted, but they they needed us in, so they just appointed us. But anybody, any suckers who were.
Planning commission member.
Yeah,
Yes. Yeah, they can appoint.
so it sounds like they may have been appointed
Okay,
versus.
yeah.
And
It may be in our town plan too, because some of it's written out in our town.
Yeah.
Town plan.
Yeah, and the best policy is to have some sort of policy somewhere that says we appoint or elect and how many years the terms are.
Bylaws.
Yeah, or there's some sort of policy often.
Mhm.
Need to be written out because it may not have been written out. Do you
Yeah.
remember?
Yeah. It's in one or the other, but I think it's the
I
bylaw.
asked Ken because he's been actually planning commission for almost
Yeah.
2 decades.
Elected many times.
And I've been it for 15 years, and I don't ever remember reading in multiple revisions and multiple reads definitions of all of these, and whether it may be something that's in the select board's
Mhm.
records as
Yeah.
to what,
Yeah, I don't see anything in there.
yeah.
Yeah, that would be a good thing to check because it's good to have terms as well on your.
And you're gonna give us a copy of this?
Yep, absolutely. Okay. Yeah, so as we talked about, the planning commission serves as legislative functions of preparing the town plan, zoning and subdivision bylaws. They can also prepare capital budgets and programs if directed by the select board, ordinances, and then other studies. So you'll see different studies.
So
Yep.
can the select board, as was done last November,
Mhm.
step in place of the planning commission for changing bylaws?
Not for changing the zoning bylaw only under a specific, like there's a provision for like a temporary emergency change to zoning. I'm forgetting the exact wording. But there is an ability for the select board to make a temporary change. I think it's 2 years, but I can follow up with that.
1 year.
1 year, okay. Yeah, it's
Something to follow up on.
Yep.
because
Yeah, I can
that
follow up with,
changed.
yep,
And I know that they knew it was of that nature,
Yep.
i.e. temporary.
yes,
And yet, if it is, we want to make sure that at some point it was made either
Yes.
permanent or revoked.
yeah, then there's a process by which it either is made permanent through the regular process or revoked, so I will follow up with more information specific to that, because I don't have the exact details of that, like, part of statute at the top of my head. But there is that provision, but generally, the town plan and the zoning and subdivision bylaws always have to go through planning commission approval with the exception of that sort of temporary emergency process. The other things like ordinances and capital budget can go through the planning commission, but they're not legally required to if your town, your select board can adopt an ordinance or adopt a capital budget without an approval from the planning commission.
Like the way it works here, but yeah.
Yeah.
It looks like it is in our bylaws where it tells us about, I know I had seen this
Is
because.
there terms in there?
Yeah, the terms and stuff.
Yeah.
It's, because we just went over this ad nauseum in another meeting for something else, and they're like, no, it's in there, and I'm like, are you, what? And it was in there, so zoning administrator is a 3-year
Yep.
term, and then planning commission is not less than 3 or more than 9, and so it goes,
Are you reading that?
That's 3 or 9 people, right? But it doesn't say the term number of years.
right, I think it is in here because we were talking about this with
Okay.
Tammy, but I think it's hard for me to read on my phone.
Okay.
As much as.
Yeah, I can also do some follow-up searching on that.
In the
Sorry,
plan? Is that the
it's at
plan
the
or-
bylaws and it looks like it's page 10 and 11. So zoning. Zoning board of.
No, yeah, it's good to, a good thing to know and yeah, to figure out if your DRB is gonna be elected versus appointed.
Mhm. Definitely talked about the zoning board of.
Because if you went with elected, the situation is the select board could appoint people for the remainder of this year until next town meeting day, but then at next town meeting day, everyone would have to run.
Okay, so
Um,
it's in the bylaws.
Yeah.
Mhm.
It's not the town plan.
No, yeah.
Um,
Okay, great. Thanks.
Yep.
It's always good to have a,
Yep.
general, it says planning commission is elected, zoning administrators appointed, ZBA is not a ZBA anymore, right?
Yep, yeah, it'll
Yeah.
become the DRB.
And those were appointed, so ZBA was appointed.
Yeah.
Um,
Yeah, so that'll be a decision point that
yeah.
you'll have to make with the DRB. Is whether they can be appointed or elected.
Is there any benefit to one or the other? I mean, I guess appointing is if
Easier to fill.
if you lose someone
Yeah.
Yeah,
appointed, I think they can do that now as.
yeah, they can until then they have to run the next year. I mean, it can make it easier. Some people get nervous about running for office, so it's easier to find volunteers when you're appointed. Certainly there's also a measure of, you can consider both sides to this with a board that does development review of, on one hand, when you're elected, there's that direct accountability. On the other hand, the board that is responsible for applying the rules as written might have to make an unpopular decision because those are the rules as written. And if you're elected, that can be a challenge. With, as opposed to something like the planning commission who is deciding what the rules will be, where it obviously can make more sense to have that direct public feedback to, we like the direction you're going or we don't. With a development review board or ZBA member, you can have to make an unpopular decision because you're applying the bylaws correctly, even if that's not what folks in the town would like
Mhm.
the outcome to be, which,
That would be me last
Yeah.
year. That was tough.
yeah.
That was a tough one.
Yeah, there can be some really tough situations because it's like you realize halfway through a project that like your regulations seem to be different, but
Yeah.
you can't apply it for that project. So you're gonna have to approve that one as is and know it for the future that things need to
And
change.
you're interpreting the
Yep.
decision that the planning commission had made
Yes,
7 years prior.
exactly.
So that's the difference, is like you get to interpret it. You decide if it,
DRB.
yeah, the DRB decides they'd interpret the law of the
Yes.
planning commission has approved of.
Correct.
Which is why I've always said that they should be the same, because otherwise you're leaving somebody like what happened last time to us
Yeah.
going, I
What does this
think
mean?"
this is
Yeah.
what we meant.
Absolutely.
And,
Yep.
You know,
Yeah,
so
that's true.
Yes.
it makes it a bit
And
easier.
Yep. Yeah, so select board also functions with legislative functions within sort of the world of planning and zoning. Obviously, they do a lot of things outside of that as well, but they review and approve town plans and zoning and subdivision bylaws. In some cases, some towns send them to town meeting for vote or approval. And then they can also prepare, amend, and adopt capital budgets and ordinances. So this is the difference between having the development review board versus the planning commission and zoning board of adjustments. When you have that split model, then the planning commission is looking at site plans and subdivisions, and the zoning board of adjustment is looking at conditional uses, variance and waivers, and appeals of the zoning administrator's decisions. Whereas with the development review board, all of the development review is done under one process. So now your planning commission functions will be just working on plans and bylaws. And anything else that comes up, specialty plans, ordinances, if you wanted to do a capital budget, for example. And then the development review board will do all of the things that relate to specific projects. So I think that, is a neater way to do it, because you're having one hearing at the development review board versus having to have like two, like a kind of weird split. Yeah, yeah. And if one day you wanted to have slightly different membership on the boards, like if someone wanted to only be on one or the other, you can do that. The membership can overlap pretty much completely, but doesn't have to, with the only exception being, like, for example, your zoning administrator can technically be a member of the planning commission, but the zoning administrator can't be a member of the development review board since they're responsible for the appeals of the zoning administrator decision.
And
Appeals
doesn't
or appeal.
DRB have to have 5 members?
Yes, and DRB has to have 5 members, planning commission can have as little as 3. So, and if you can, it's really great to have alternates on your DRB, because you have to warn those hearings in advance. So that way, if you don't run into quorum issues as easily, you can have alternates that step in for that meeting.
So the minimum is how many on the DRB?
Is 5 for
It's
the
5.
DRB.
So
Yep.
quorum's 3.
Yeah, so quorum is 3.
Yeah.
Yeah. So that is where it can be useful. You are able to have alternates on a DRB, and that can be valuable if you have enough people.
Hard enough to find.
I know, to find 5, I know. Right.
What are you saying? People have been flocking to that. My phone's been ringing off.
Everyone loves the volunteering to work on their municipal government. Yeah, and then there can be, some towns have advisory boards. I won't go over that too much because that's a pretty specialty issue. Yeah, and then you have the zoning administrator. They respond to questions from residents and property owners and developers. They help coordinate the review of applications. And then for things that are permitted uses, which are non-discretionary review process, they review and issue or deny zoning permits for those projects. They also conduct enforcement of the zoning bylaws. In most towns, that's like a complaint-based system. And then in some towns, they also serve as the clerk to the planning commission, DRB, or ZBA. So that's one thing to consider is your zoning administrator able to be the one that writes the decisions for you? Or do you need someone on the board to do that? It just depends on the town and what your zoning administrator's hours look like and his contract. And then, yeah, they can be authorized to perform certain review processes for development proposals. Like in some towns, for example, small subdivisions or bylaw or boundary line adjustments are reviewed by the zoning administrator. Yeah. So the appeals process works so if you have something that's a permitted use and the zoning administrator makes the decision, then that can be appealed to the development review board if either the person or another interested person in the decision, like a neighbor, for example, disagrees with the decision, they can appeal to the development review board. If you have a decision of the board or the board decides on an appeal, and someone, either the applicant or an interested person doesn't like that, or then it gets appealed to it's technically called the Superior Court Environmental Division, the environmental court, for the state of Vermont.
Can I just go back for a second? You were
Yep.
talking about the zoning administrator potentially being able to do
Yep.
boundary lines adjustments or something. Is there some sort of formal language that needs to?
Yeah, it would be in your zoning bylaw. You can say the process for the boundary line adjustment is so that it's approved administratively by the zoning administrator. So it would be an amendment to your zoning bylaw. That was, for many years, there was sort of a legal gray area. Some towns were doing it and it wasn't clear if you could. And then 3 years ago now, in 2023, the legislature, when they made a bunch of changes to the statute, made it clear that towns can do that. And we'll get into this more later, but these are the people who can appeal development review decisions, which include the applicant and interested persons, which are the municipality and adjoining municipalities, someone who owns or resides in property in the immediate neighborhood of the proposal. So either someone who's living a neighbor or someone who owns property or both. Any 20 persons in the town, which can be a combination of voters, residents, and property owners, as well as departments of the state that own property in the town. And they have to participate within the hearing process to appeal. So there's a bunch of links here that you can see. I'll send it to you, and these are all hyperlinks. We recently just did, as the RPCs, an update of the whole zoning administrator's handbook, which goes through a lot of the common issues that zoning administrators face. But it can also be useful for development review board members sometimes, and kind of walking through a lot of the common issues that come up in some of the legal precedent around those. We had a lawyer collaborate with us on getting that updated, which is good.
So does that mean that Brian could have been doing some simple boundary line adjustments without?
Oh, it's not in our bylaws, right?
Yeah, when you do, in the
You'd have to
future.
put it in the bylaw?
Yeah, you'd have to put it in the bylaws. But that can be a way to, just one, it makes it easier on the applicant, and two, it makes it less work for the DRB if, something's gonna be a simple boundary line adjustment and there's no real concerns.
Yeah, like
It
the
is kinda
gentleman
gives
that,
us something to do.
Yeah.
Occasionally. But
Yeah, and it depends on the capacity of your zoning administrator, right? And whether or not he has time to do that. Yep. So going more into what is in your zoning and subdivision regulations. So the zoning and subdivision regulations should basically be the implementation of the goals and policies of your town plan. So your town plan sends out your general goals and policies for future land development, and then your specifics of how you're going to accomplish that are within your zoning and subdivision regulations. So you want those to be broadly compatible. And the reasons to have them are basically to implement those goals and visions of your municipal plan. Like if you're trying to encourage growth in your village, but protect your natural resources, encourage your efficient use of whatever town infrastructure you might have, flood resiliency through flood bylaws, all those sorts of things that are within your town plan can then be implemented through specifics in your zoning regulations. So the zoning regulations basically regulate anything that can be land development. And the definition of this does vary across town. So look at your own zoning bylaw for this, but generally that can include the division of land into 2 or more parcels or boundary change. So those are things we would broadly consider like subdivisions and boundary lines adjustments, construction, conversion, or structural alteration and enlargements of buildings and structures, the mining, excavations, and landfills, and then also the change of use of structures or buildings or uses of the land. So zoning kind of regulates both the physical structures themselves, but also the uses of those structures. So something can have no physical structural change, but need a zoning permit because it's going from, say, being a residential home to being a commercial property. There are some limits on what you can locally regulate. So Vermont's a Dillon's rule state, and what that means is that the power that municipalities have is bounded by what is specifically enabled in state law. So the state gives power to the municipalities essentially. And so within land use regulations, there's statutory limitations and prohibited effects in the statute. So all of the statute for planning and zoning is in Title 24, Chapter 117. And within that section 4412 and 4413, basically you go through a whole laundry list of things that you can't do with zoning. And then there's also the constitutional guardrails, which is that through sort of extensive court cases all the way up to the Supreme Court, land use regulations can tell people what they can and cannot do with their property, but they can't deprive landowners of all use of property. Basically, you can't essentially take someone's property. That would be eminent domain. You have to pay someone for that. And something else to consider is that conditional use review has also very specific standards associated with it. So it's not unlimited license to regulate anything. That's something some communities are not aware of. And then also be aware of the fact that over the last couple of years, especially in 2023 and 2024, there have been a number of changes to state law specifically around housing and what the municipality can and can't regulate in terms of housing. So for example, the minimum allowed size for an accessory dwelling unit, allowing a duplex in any district where a single family home is allowed. So be aware that those changes have happened. They might not be written into your zoning bylaw, but they still are in effect because of that fact that Vermont is a Dillon's rule state. So as noted, there's these different types of review for zoning. Things are generally a permitted use. So those are things that are by right and permitted by the zoning administrator based on non-discretionary standards. There's conditional use, which you can kind of view as viable with conditions. And that's what gets reviewed by the Development Review Board. And then exempt uses, which are either exempt by state law or under your bylaw as locally exempt development that don't require a zoning permit. So for example, most towns will have an exemption for some amount of landscaping and grading activities so that when you add some garden beds, you don't need to go get a zoning permit for that. And then there's also state exemptions, well, this is now a more complicated example than it used to be, but traditionally we've understood agriculture, for example, to be completely exempt from local zoning. And then there's subdivision review. So that's where you get your zoning and subdivision regulations, which is the division of land into parcels. So there are some towns that have only zoning and not subdivision, but in your case, you have both. There's site plan review, which is looking at good site design via specific standards, and that can be applied to a permitted use or a conditional use. And then there's variances and waivers, which are both mechanisms to grant flexibility for development that doesn't meet standards. The variance is a provision set out in state law with really strict guidelines, and the waiver are locally defined provisions that can be a bit more flexible. And there's also the planned unit developments, which allow for those more flexible design of lots and often are used to promote clustered development. So these are the conditional use criteria. These are the general criteria, and you can add other ones within your zoning bylaw. But basically, when you're looking at a conditional use, you're looking at the capacity of the existing or planned community facilities. So like, do the roads have capacity? Do the schools have capacity? Any municipal infrastructure you have, essentially. The character of the area, and I think it's important to know that this is defined by the zoning district purpose statement and the language within your municipal plan. So this can be a really hard one for development review boards or ZBAs to look at, because people may have a lot of different ideas in their head about what the character of the area is, but what you're trying to really apply is what's written in the town plan and the zoning district purpose statement. The traffic on highways and roads, utilization of renewable energy resources, and other standards that are defined by the municipality. And I put this little asterisk on character of the area because one of the new changes for the statewide housing law is that you can't use that for conditional use review of 3 to 4 unit housing, so triplexes and quadplexes. So that's my,
Better to have very specific
yes,
in your bylaws.
yeah, in your bylaws.
Yeah, what the board decides is a character. Maybe.
Yes, yeah, I think the more specific you have it in your zoning district purpose and also the language in your town plan, the more likely it is that it will hold up and you're not going to have, you know, generally the more specific you can be, the less likely you're going to get an appeal, and appeals can be costly. Once things go to the environmental court, you have to decide if your municipality is going to defend your decision or not. And if you are, you have to hire a lawyer, and that's expensive. So, yep. Yeah, it's not fun.
This is an important
Yep.
topic,
Yeah.
and trying to figure out where you find that. For
Yeah.
example, I'm looking at the town plan,
Yes.
and it's got community profile.
Yeah. So usually it's like in your land use, future land use section. But I don't remember exactly how your town plan is
I mean,
organized. It's been a little bit.
It seems like that it would be really valuable just to be direct about things, like
Yep,
this is the character of
yes,
Bakersfield.
yep, absolutely.
And because if
According
it's
to-
statutory,
Mhm.
it is easier if you have a direct statement versus some sort of interpretation that
Absolutely,
can be different between
yeah,
various people.
Yeah, like on page 82 is like Emily said, the land use, that's our land use chapter, and there's some kind of there's some talk about what the character of
So we
Bakersfield.
should remember that as we're looking at
Yeah.
the
yeah, that's a good
revision of
thing
the
to look
town
at,
plan.
making sure that that really matches with what you want included.
Okay, yeah. A lot of power, DRB characters.
Yep. And then the other piece of that is the site plan review. So when you're looking at that piece, for a project, you're looking at more the design of the site itself. So you can think of conditional use review as how does this fit within the neighborhood, the character of the overall area, where site plan review is like, what are the facets of this project within the lot that we could adjust to improve things. So for example, things like landscaping and screening, so like screening a parking area, the traffic circulation within the lot, the lighting that's associated with the lot, making sure your lights aren't, shining right into the neighbor's house, for example. But it differs from conditional use review in that there's no argument within the site plan review side of the process about the use itself. It's just about how it's designed and laid out. So that is a benefit of having the DRB model, is that you can be looking at both. If something's a conditional use and you need to do site plan review, you can be looking at both of those at once, rather than having this weird split where you're trying to like only look at the site plan and only look at the conditional use. Yep, and then subdivisions, which are what control the future pattern of development, the layouts of the lots, roads, and then also sidewalks, infrastructure, protection of natural resources. So as I noted, the zoning administrator can be responsible for boundary line adjustments, and also in some communities is even responsible for minor subdivisions. That tends to be in larger communities that have full-time zoning administrators and see a lot of subdivision. But, and then the DRB can be responsible for all other types, including must do all major subdivisions. And minor and major are defined by the municipality. So as I noted, the waivers and variances are two of the ways that you can provide flexibility. So the variance is a very specific legal test that's provided in statute to allow for development, not in conformance in the bylaws, in basically specific limited circumstances in which the physical circumstances of someone's lot that were not created by the applicant prevent them from reasonably developing their property. And it must be the minimum adjustment to the bylaws that will afford relief. So in practice, it's very difficult to grant a variance in the state of Vermont. It's a very limited provision of relief to try to make sure that someone's doesn't have a lot that they can't develop at all. Because it's so strict and difficult to grant, some communities also decide to include within their zoning bylaws waivers, which allow for relaxation of certain standards, for example, setback standards in set circumstances. So an example of this is some municipalities will allow you to waive the setback standards a certain amount when there's something like a wetlands on the property. So you need to move the whole thing to one side, for example, to avoid the wetlands. But you need to make sure that there's clear standards and process for those set in the bylaws. So you're not just, saying you don't have to follow the bylaws.
You can't grant a waiver for something that's sort of not
Yes.
bylaws or.
Yeah, you can't grant a waiver unless it's like essentially the absolute minimum to allow some level of reasonable development on the lot. So it's really limited.
So the variance, is it generally only on like lots, like land, actual land, and not necessarily on actual buildings or?
It's buildings.
It's a building, yeah, it's like a building on the lot, like, it's like if you have a pre-existing small lot where like 90% of the lot is wetlands, maybe you could get a variance on the setback, for example, but it's very difficult because you have to essentially prove that it's the least variance you need and that it's like absolutely required based on the physical conditions of the lot.
It was like that, the one that came before us, they needed a variance because it was, our building was, limit was 35. There were 44 and a half.
Right.
And they wanted a variance from that so that they could
Subtitles.
build,
Yeah,
but
that's what I was, because I mean,
Yeah.
I'm only talking about lots more than that. And I was kind of thinking about that building.
Yeah.
Like out of,
Oopsies, what did I do here? Oh gosh,
Mhm.
okay, I've gone the wrong way here. No,
and that was a tough one too, because they had already done it.
Right.
Then they came and then we're.
yeah, and that's that's a tough one,
We're like,
especially when it's height, because that's not really.
yeah, well, people go by it's easier to beg for permission than,
Yep.
Or
forgiveness.
for forgiveness
Mhm,
and ask
yeah.
for permission
Yep.
kind of like thing,
That's a tough one.
but that was hard.
Yeah. So yeah, in some cases it can make sense to set waivers so that you can kind of avoid that variance situation and set a simpler to follow process that, considers like the reasonable waiver rather than like this is the absolute minimum deviation from the bylaw that's legally required. And then there's also planned unit development, which essentially allow more flexible standards as a carrot for either good site design or other goals as a municipal plan, like clustering of development, or in some cases, for example, development that the municipality is specifically looking for, like senior housing. So probably the most common example is a conservation subdivision where you allow smaller lot sizes, clustered development, and then protection of the open space. Some municipalities also use this to provide density bonuses for projects that support affordable housing or senior housing. And then there are also examples of non-residential planned unit developments, which are generally used to address unique development types, things like medical and education school campuses. This is really more about planning commission, some planning commission slides here that talk about the actual development of the zoning bylaw. So I'm gonna skim through these a little bit, but feel free to stop me. But your bylaws are generally set into different zoning districts. Looking at, starting from the protection of your agricultural and forests as your working lands, the sort of conservation areas in some cases, looking at the rural lands, which is really the majority of Vermont, a mixture of agriculture, forests, but also rural housing. You can often see it at sort of neighborhood areas, which are those more denser residential areas. And then you get into your village and downtowns, which tend to be more mixed use, commercial and residential. And then you can have special use districts, industrial probably being the most common one. Some communities also have areas that are set aside just for commercial uses, although that's generally not as recommended. Either they should be, commercial uses are generally best mixed in with your residential uses, unless they're meet that sort of industrial standard where they're incompatible.
So are the zoning districts
Yep.
defined at the state level?
The state defines what types of zoning districts you can have, but they don't define exactly what what those mean, if that makes sense. They say like you can have ag districts, rural districts, forest conservation districts.
Yeah,
But they don't define exactly what those mean. So what those exactly mean within your town are defined by the zoning district purpose statements.
right,
Yeah.
and obviously, if they're not necessarily defined by state,
Yeah.
then you could have like the rural district is different in Bakersfield versus
Yep.
Montgomery.
Exactly. Yeah. Different communities have different standards. I think there's a pretty broad, within sort of like rural agriculture, forestry districts with the state, there's a big variation in, what lot size is allowed, what types of uses are allowed. It's definitely not standard.
And
Every
then who
community is
has
unique.
jurisdiction when a property crosses two town boundaries?
I believe that it would depend on the portion of the property that's being developed, but I believe in each zoning bylaw, there's usually a section that addresses properties that cross the town line. And there are some specifics if you're built, I believe, for properties that are like actually building on both sides of the town line.
Right.
But I can follow up with the very specifics because I don't have them at the top of my head.
Yeah, we've had it happen a few times.
Yeah.
and We tend to think we should hear from both,
Yeah,
where I'm not sure it's defined
yeah, there is
how you do that or
yeah, I think there should
when you do
be a
That just happened
second.
recently, right?
we had the one with the development of the farm between Innsbruck and Bakersfield. We've also had development of more rural, no, more wooded land between Fairfield and Bakersfield, where that was made into housing. And,
Please.
you know, you sometimes think that the structures and roads and buildings would create some definition of one being stronger for the town
Fiction.
of the two, but it's not really clear, especially if you have kind of equal amount of development in both.
I don't have it in your zoning bylaw. I can also follow up with the state statute language there, because it is addressed in statute and a lot of bylaws include it in it, but yours doesn't.
Yeah, that's why I was
Yeah,
thinking about it. And this is kind of off the
Mhm.
specific content that you're reviewing. We've had the tendency to revise the bylaws after
yep,
we revise the town plan.
yes,
And we definitely, in looking at the bylaws currently, and maybe the town plan slightly less, I
Mhm.
think the bylaws are very clearly out of sync with the DRB and planning commission versus planning commission and zoning board of adjustment.
Mhm.
So it's going to be a major
Yes.
revision of this.
Yeah,
And are there models that are useful to see what bylaws could look like if you have a DRB and planning commission? And from what I understand, we may be the last of few municipalities changing.
a few in our region.
Right.
Yeah, we have like, I mean, I think the main change would be that sort of like Article 1, Article 2, where it talks about essentially like administration and proceedings. And we certainly have at NRPC with kind of like a rough working template of what those sections look like. So we could send you some examples from other communities that have that DRB model.
And has the NRPC converted a town's bylaws from DRB or from ZBA and PC?
I'm sure we have. I haven't, but I'm sure we have over the years. Because it used to be that almost everyone had a planning commission and ZBA, and then
Because we're in this really weird
Yeah.
place where we're acting
Mhm.
like a DRB slash planning commission, but our bylaws that we
Yeah.
are essentially making
Yeah.
decisions on the basis of them are not written for
Yeah.
planning commission and DRB.
yes, yeah,
So it would be kind of like you would want to revise them
yeah, it would
pretty
be,
quickly,
yep,
or even do it before you make the transition, which we've already made.
yep. Yeah, we can send some examples of that sort of model language that we have around those articles that were essentially address there might be some control F in the other parts of the bylaws, but I think the main changes are the parts of the bylaws that talk about how the bylaws are administered in the process for a public hearing.
Yeah, it makes sense because most of the rest are kind of standards for
Yes. Yeah, those are.
kinds of development as opposed to who has
Yep.
what authority.
Yep. so we talked a little bit about these different types of uses, which are permitted, conditional, and exempt, and then things that are just not permitted or prohibited in the municipality. And the types of typical standards you can have in your bylaw. Most communities regulate density through a minimum lot size. But there are other ways that communities do it, like having a maximum number of dwelling units allowed on per acre. So that's separating out the actual lot size from the allowed density. And then in more urban municipalities, they see things like floor area ratio and lot coverage standards that essentially address how much square footage your building and structure can have relative to the lot size. Those aren't really necessary in rural municipalities generally, but some rural municipalities use the maximum dwelling units per acre rather than minimum lot size. And then dimensional standards, which are things like the setbacks, the required road frontage, and the allowed heights of buildings.
And those two are kind of like the zoning districts defined by municipalities, not the state.
Yes, yep. All of that is essentially defined by the municipality. There are like a few places where provisions around height relate to, there's some state law related to that, but those are only in communities that have water and sewer. So those communities are required to have a certain amount of areas that have water and sewer. With some of the new laws that were passed in 2023 and 2024 are required to have a certain minimum density, but those do not apply to areas without water and sewer available. So for rural communities, it's essentially all defined by the municipality. And then other types of common zoning standards you'll see are access standards. What type of road or driveway do you need? When do you need a road versus a shared driveway? Again, that's defined by the municipality. The amount of parking, if any, that a use might need. Again, in rural communities, areas that don't have water and sewer, that's entirely defined by a municipality. Screening and landscaping, do any uses need to be screened from other uses? So a common one is, for example, requiring a commercial use to screen their parking against a residential property, for example. And then things like fences and lighting and signs, things that you're thinking about, how can we prevent nuisances to neighbors, essentially. And then there's a whole list of special cases and limitations here. There are really a lot of these public facilities, group home and home childcare, home occupation, agriculture and forestry. I'm not going to sit here and talk about all of them, but I'm happy to talk about any of them if you want.
One that we're sort of dealing with
Yep.
right now, like a telecommunications tower.
Yep.
Or, like wind turbines, and
Yep.
is it better to have specific, language? Is that what we should be talking about right now? Or is this just kind of something that could be ruled on by the DRB?
Yeah, so for renewable energy projects, that would be, so anything that's attached to the grid essentially, is not able to be regulated under local zoning. So it goes through the state's section 248 certificate of public good process. And through that process, they look at your town plan. So it's, and if you have one, an enhanced energy plan. So that's the best place to have, like, if you have a clear policy on wind turbines, for example, it does need to sort of align with your policies on commercial developments generally. So for example, like if you have a policy that like prohibits wind development on ridge lines, it should align with essentially your policies in your town plan about development on ridge lines for commercial use, for example. For telecommunications towers, they're technically, they can still go through Act 250 and local zoning review, but the state created this alternative process, which is the Section 248A process, which is also through the Public Utility Commission Certificate of Public Good. And that's the process essentially all developers use because it's easier for them. And so for that, they are again looking at your town plan But in that case, if you have a reference to it in your town plan, you can reference your zoning bylaws in your, comments. As part, if it's, if it's connected to the goals and policies of your town plan, to provide additional clarity, but again, it is a situation where you are essentially providing comment to the Public Utility Commission, who's responsible for making the final decision. So both of those are out of the direct control of the municipality. Any other of these that you have specific questions on?
Is there a reason why some of them look like they're,
Oh, no, they're just fun colors.
it's like some of them look like they're faded, so I didn't know if that meant,
No,
don't worry about these ones. So, no, we have to worry
No.
about all of them.
Yeah. Well, yeah, there are different sort of provisions that you should be aware of.
Small multi-units that be like tiny houses or something like that.
That's the 3 and 4 unit multi-units, which is where you can't use the character of the area for conditional use review. And then the other limitation there is that every municipality has to allow those somewhere in the municipality. So like usually it's in the village, that they're allowed. You essentially have to allow.
Didn't the state just lift that? Because I think they're trying to put one down down the road from me is a multi-unit, where the crack house, that what I'm talking about? It's like 2 driveways down past me and they actually had to remove the house and that's where they had the meth house.
Yeah, I remember you talking about that. So
Yeah.
they want to do what there?
I was told they were putting like a multi-unit, like 2 or 3
If
units in there.
if it's duplex, if it's 2, you can put that now. It's allowed anywhere where a single family would be allowed.
So it's
but-
probably a duplex.
So it's probably a duplex, because the 3 and 4, you can still limit to just a specific zoning district
Yeah.
in a rural municipality. Again, if you have the areas with water and sewer, there are different
Mhm.
provisions that don't apply for Bakersfield. Great. Yeah, and anytime you come up to something you're not sure of, you can always reach out to us at the RPC because
What does non-conforming structures? I'm assuming it's like the tower that went up, the 44.5 tower that wasn't really conforming. Is that what you're referring to?
So that's referring to things that were built before, like the zoning bylaw changed essentially, or before there was a zoning bylaw. So like sometimes you have like an old building that's, built like right on the road. And then most bylaws have a specific section about and then also it can be a use, for example, like maybe there was always a business that's in the conservation area and it was from before the zoning bylaw was ever in place. And most zoning bylaws have specific standards about how those can be addressed. Generally with a non-conforming use, you can't expand that use, but you could continue doing it as long as it's continuous. So like, let's say you had a store up in a conservation area and it's been there since before the zoning bylaw was in place, as long as it's continually operating as a store and not ceasing operations. For different bylaws have different time periods, it's usually like a year or 2. It can continue that use. And same thing with a non-conforming structure. Generally, you can keep your non-conforming structure once the zoning bylaws come in place. And for most bylaws, they allow that you can expand the structure as long as it doesn't increase the non-conformity. So like, let's say you have a building that's too close to the road, doesn't meet the front setback, but it was built before zoning. If you want to add an addition to the back of your house, that's fine. You just can't add an addition, in the front where it would be further towards the road. So that's to basically address that, if you already have something going and then you change the bylaws, it doesn't all of a sudden make your house illegal or your use of your property that you were already doing illegal.
It's kind of like grandfather.
Yeah, grandfathering, yeah.
Yeah. Okay.
And that's the same thing with existing small lots. If you had a lot that was existing before the bylaw and it doesn't meet the minimum lot size, as long as it's at least 1/8 of an acre and at least 40 feet deep, you can develop it. So like a lot of times in villages, you'll have these like really small historical lots.
Mm. I think, I mean, do we have anything in our bylaws right now against tiny homes? I really like the idea of people building tiny homes.
I don't think so.
Yeah, usually in Vermont, because, there's most communities don't have any sort of minimum square footage for homes. One thing that you can add to your bylaw is like a provision, sometimes we call it like cottage court development, that makes it easier to allow multiple primary dwellings. So if someone wants to put up like a couple tiny house, like a little tiny house village, that you can add provisions to make that more possible, because that generally isn't possible under current bylaws because you can only have one primary structure. But usually if someone's just trying to put up a single tiny house or trying to use it as an ADU, both of those would be permitted. Most bylaws in Vermont say that if you have any sort of mobile structure, as long as it has skirting and is, kind of attached semi-permanently, it will be treated as a structure. And Vermont law specifically protects like manufactured housing, mobile homes, things like that, as to be treated as a equivalent to like a conventional house. So that those standards also often apply to a tiny house.
I really love those little tiny communities. They're so cute, the little
Yeah.
tiny homes.
Yeah,
I think we should encourage more just because the affordability, I mean.
yeah,
I don't know how
Hmm.
kids do it now, go out on their
Right.
own.
yeah. So you can look at things.
400,000 for a house. Who can afford that,
Yeah.
They're all gonna be living off the property of their parents pretty soon.
Yeah.
Don't say that.
Kids do that again,
Yeah.
too. We almost did. They were gonna build on our property but then they found one in St. Albans they
Yep.
liked.
Yeah.
Darn it.
Great.
One question I have.
Yes.
And I'm not sure if you're gonna get to it yet, but I remember for the ZBA board.
Yep.
That we had our emails culled. They're trying to claw back the emails.
Mhm.
Do you recommend DRB have an official email because of the fact that?
Yeah, I think it can be a good practice in terms of if there is a public records request,
Yeah.
that way it's easier to just be able to send in everything from your DRB email rather than having this awkward situation of having to go through and like be like, these are my DRB ones. And this was, especially if you're emailing each other just like for other reasons, like, and same thing with like texting, it can get kind of like difficult if you're texting Bill about like the community supper and then also about a DRB thing and there's suddenly a public records request and you're like, well, I don't want all my texts about the community supper to enter the public record. So it can be useful to have that separate email to just make it easier to say, okay, here's all of my official business, rather than having to go through your own personal email and being like, these ones are personal, these ones are town business. Because especially in a small town, it is easy for that, or for there to be overlap there.
Twice, each time we had
Yeah.
someone come before us, they asked for a copy of our emails,
Yeah.
correspondence, and
Mhm.
and we're like, okay, and let me take the time to. Then you have to. Whereas if it's on a separate email,
Yep.
that somebody oversees, like the select board, creates
Exactly.
this, they can shut us off and on, and they can archive it.
Yep.
So when it goes to your personal emails, they have access technically to your personal email.
Exactly. Yeah.
And that gets a little, and I've known people
Yep.
who have had that happen to them where they've had to go through and look at. And that I read, it does not have to me, it would make sense if the town paid for Outlook,
Yep.
but I don't know if they will.
Yeah.
And so if they don't, are they okay to just use a Gmail?
Yeah. Yeah. You could set up like a Gmail.
As long as it's set up by someone other than myself, saying heather.jewett at
Yeah.
drb.
Yeah. Yeah. If you have the select board set it up as like DRB.
Yeah, because I think John West could do that.
Yeah. Yeah. I think it's a good practice. It just makes it easier if there is a public records request where you're not sort of having to send over your personal emails, which can kind of feel like
Yeah, they can,
invasive.
they can literally take every single one of your devices and call through them. Whatever you've used. So that's why you always have it on a separate email.
Yeah, it's good to have a separate email. I think it's a, there are, there's limitations, but again, it's like attorney time to be like, we've had this come through of, there's limitations, for example, of certain things which are, like when I was going through was we had a lot of emails with our attorneys on a particular, it's a project review project where we had a public records request, and I had to go through and redact every single one of those and then work with our attorney to make sure I was citing the right part of statute that, this is attorney-client privilege discussion in this case. And that all of that's time consuming. So the easier you can make it on yourself if that does happen, which it is likely to if something gets appealed to the environmental court and now there's lawyers involved and they're looking for every possible.
Any correspondence that had
Exactly,
anything to do
yeah.
with this, and we're like, it took us hours to look
Yep.
through all of our stuff and go, oh, no, we didn't mention that.
Yeah.
So
Yes, it's not fun.
It
It's
is
part
not
of the public records request and it's important to provide public access, but it certainly can be challenging like administratively. And so it's making life easier on yourself and making it easy to separate out that town business and personal is always good.
would it be easier to have a town or DRB, and could you have a combined DRB planning commission
Yeah.
one? Okay.
Yeah, you could have a combined DRB one.
And then just have one individual instead of, I know in the past they said just have one and we all had to share it. And I was like, that's stupid because as soon as Ken read it, then I wasn't notified of it.
Yeah.
Or as soon as I was read it, Ken wouldn't be notified of a new email.
Yeah, what a lot of towns do, like sometimes assign it by name, but I think that probably the easier system is to have like DRB 1, DRB
Yeah.
2. That way, when the board turns over, you don't have to like create a new email. You just turn over who has access.
Yep. And that can be Gmail as well.
Yeah.
Okay.
Yeah, you can use whatever email client works best for you. Gmail is free, so that's a good deal.
Yeah. That's probably what the town will go with.
Yeah. Right. And then these are a bunch of linked resources. There's the ACCD Enabling Better Places Guide, which goes over a lot of the different sort of zoning and subdivision pieces. There's the other planning modules as well, some information from VLCT and VAPDO, which is basically all of the RPCs working together. And that's it on the overall overview of zoning and subdivision. Any other questions on that before I move into the due process hearings and decision making?
Trying to figure out what ACCD.
Oh, yeah, ACCD, sorry, I live in acronym land. It's the Agency of Commerce and Community Development. So they're the state agency that is designated to basically do land use planning from a state level and provide resources to municipalities. And they're the ones, for example, that fund the municipal planning grant program. And VLCT is the Vermont League of Cities and Towns. Yeah, okay. Yeah, sorry, this is me living in. This is also helpful because this is a new presentation we've put together. So, so you're guinea pigs right now, like write out what ACCD means.
Do a little letter.
Yeah, no, I'm sorry. I live in like acronym soup. So sometimes I forget that not everyone else is living in my particular acronym soup. So land use decision making. So as I talked about, when you're acting as the development review process, you're acting in this quasi judicial process through a hearing. And it's really important there's a statutory duty to have due process. That's protected for the applicant and the interested parties. So that comes from the Constitution, the idea that you have due process under law. It's also really important just in terms of maintaining and fostering the public trust in the decision-making process. If the public feels that the process is transparent and clear to them, it's much more likely that they're going to maintain that trust that the process has been fair. And then understandable. You really want to have clear rule of procedures and ethics policies, and the Vermont League of Cities and Towns has models of those if you don't currently have them. I don't know if you currently have a rules of procedures and ethics policies adopted, but it's really good to have those, especially an ethics policy, because with the new laws that were passed, the state, there is a specific process by which a municipality needs to address if they get a formal ethics complaint and address that complaint in a sort of formal manner. So yeah, I can send over.
We have ethics, but I don't know if it's been defined.
Yes.
We
Oh,
are-
Yes. Yeah, it's not you're trying to act in an unethical manner, but having those clear set of rules so you know, like, okay, this is the clear process of, okay, I need to recuse myself now, or this is the clear process for disclosing my conflict of interest. It just helps protect you and it helps make it clear to everyone. Like I said,
And does that usually get added into the zoning bylaws?
it's a sort of separate policy that's adopted by the Development Review Board. Yeah. So it'd be a separate policy that you adopt, and I can send the Vermont League of Cities and Towns has like drafts of those that are pretty plug
Yeah.
and play.
So we could just adopt that one?
Yeah.
That makes sense.
Yeah. Yes, ethics is like conflict of interest, things like that, and then the rules of procedure are like the sort of physical layout of how the hearings go, and it's just helpful to remind you of all of those steps, which we'll talk about tonight. We know that making an effective decision is hard because the review process asks us to be things that we kind of usually aren't in our day-to-day life, which is very formal, precise in our decision, decisive, yes or no, and clearly justified by relating it to the zoning bylaw. So it's in many ways a very unnatural process, especially for small town Vermont, where we're often talking to people that like are our neighbors and that we know. And we're asked to enter this very like formal setting and formal process. So the folks who are involved in the hearing are, in this case, the Development Review Board, town staff, which, like I said, is oftentimes the zoning administrator who supports the Development Review Board, the applicant, the interested persons, and in some cases, municipalities, they have advisory panels. For example, like a historical design review panel. So the applicant's role is that they're basically an advocate seeking approval for their project. And in addition to being represented by the property owner, they can often be represented by the engineers, consultants, or sometimes attorneys. They'll present evidence on their project. They can ask questions of other witnesses involved in the hearing. Question any written evidence presented by other parties. And also can appeal at the decision that was made to the environmental court. The board's role is basically to determine the project's conformance with the regulations while also protecting due process. So you're listening to the testimony and evidence that's being given by the applicant as well as any interested persons involved in the project. You're asking questions that are related to the project and are kind of as neutral as possible. You're referring to your regulations to understand what the standards are. You're addressing any conflicts of interest, and you're basing your decision on the evidence presented. And it's really important as a board member to not sort of prejudge a matter or publicly express opinions on a case that's still ongoing. So when you haven't closed the hearing, you're not making a decision yet. You're not sitting there saying, oh, I don't know about this one, or things like that matter. And also I think, especially when you're serving this dual planning commission development review board mode, it's really important that when you're in this sort of hearing development review board mode, you're not addressing those sort of policy questions of like, should our regulations be this way? It's fine to then, later as the planning commission outside of that formal hearing, process at a planning commission section of the meeting, say, hey, this project is really bringing up that we have these issues in our zoning bylaws that aren't clear enough or that aren't reflecting what the community wants, and we should address this or note this down for the next time we do a zoning bylaw. But you're not doing that within the hearing process. You're kind of keeping that policy decision-making side of it separate from the reviewing of the case itself.
You're okay to talk about it before it comes to you as an official hearing. Like if
Yes.
you hear somebody talking about it, I mean,
Yeah.
you can talk about it, but the important thing is once you're in the hearing,
Yes.
try and
Yeah, you want to avoid any conversation with the applicant or any other interested person about the case in the process of the case. That's called ex parte communication, basically communication that happens not during the actual hearing itself. if it does happen, because it does happen.
Oh, yeah.
The most important thing to do is the next time that hearing is open, you just immediately disclose, I was talking to so-and-so and this came up and this is what was said. And then you're reading that, you're putting that into the record and you're essentially curing any issue that you've created.
I know with the last case that
Yep.
was happening where the appellant was reaching out to me.
Yep.
And asking me, and then the lawyer finally had to say,
Don't do this.
an answer.
Yep.
And then had to address the person.
Yep.
And the next time we're saying you are not allowed to approach.
Yes.
Because then you're asking basically me to make a decision,
Yes.
give guidance.
Exactly. Yeah. Everything needs to be done within the context of the warrant hearing and not outside of it. And it is hard because people are
That's tough
calling
when
you.
you're neighbors.
Exactly. How
I
people
like to
are.
be, I try and think of myself as trying to be nice to people.
Yeah.
And that was tough.
Exactly. And that's the really hard part is it like requires you to take this like stiff formal approach that is really not natural to people.
Yeah.
And I think that's where it really helps to have those written rules of proceeding where you can say, I'd love to talk to you about this, but I have to follow this way for the process because it gives you that thing to point to. It's not me trying to be mean about this. It's just this is the way the process is working and this is how we're doing it. To make sure it's fair to everyone. Yeah, and then your quorum, you need to have a quorum of the board to act in a hearing. It is the majority of the board, including unfilled and vacant seats. So even if you only have, 3 members out of 5 seats filled, your quorum is still 3. So that's the challenge of having unfilled or vacant seats. One or more members can attend the meeting remotely and can fully participate in the discussion and vote, but at least one member of the board or town staff member must be physically present at the designated meeting location. So the board chair keeps the agenda, keeps the board members focused on the issue at hand, and ensures the board finishes on time. They state the questions asked for discussion and try to bring the board to resolution after discussion. So knowing kind of when has all of the questions that could be asked about this project have realistically been asked, and it's just time for us to make a decision. As I noted, the zoning administrator or other roles such as a board assistant or a town planner, which Bakersfield does not have, but larger communities sometimes have, may be providing some staffing support to the DRB. So typically a zoning administrator will be responsible for receiving the applications and determining if they're complete and ready to be sent to the development review board. In some communities, they'll prepare or notice agendas. In some communities, they can also provide like a staff report on the application. Again, that really depends on the capacity of your zoning administrator, but if they have capacity, it is a great thing to be able to provide. They may provide relevant information on the property or historic decisions. In some communities, they even provide recommendations to the board. Again, that tends to be in larger communities where the zoning administrator has more of a full-time role. They can help coordinate and support deliberations. And then in some communities, they also write the decisions. So I think you have to kind of think through in your community what the zoning administrator has in terms of capacity to support the role and what the board will need to do. Like, does your board need to write your own agendas, or can the zoning administrator or someone on staff do that? Same thing with writing the decisions.
Yeah, seems like right now we're kind of distant from our ZA.
Yeah.
We're kind of doing all that stuff.
Yep.
Take care of permits and.
Yep. Yeah.
But if we could coordinate a little more, but I don't think he has much interest in coming to this meeting.
Yeah.
So-
Yeah, so it may be that you have to, as board members, write your decisions yourself. In which case it's good to just have like a system for who's gonna do that, make sure someone,
If we do make a decision.
yep,
And we, instead of, in the past, we floated it past the
Mhm.
lawyer, just to have them do
Yep.
it with you, look over it. Is that something you folks can help us out with, or are you guys like, nah?
we can provide, yeah, if there's like particularly, if there's we can't provide legal advice, we're not lawyers. But we're happy that if there's a particularly complicated decision and you want someone to take a look at it, we can certainly provide some technical assistance of looking at that. We can't provide the same sort of stamp that a lawyer could, this is not gonna, it's
Yeah.
gonna be for sure legal because we're not trained attorneys, but we certainly have experience and can help kind of provide some guidance. Um, you know, if you're pretty sure that something's going to be appealed to the environmental court, and it may make sense to send it to your attorney anyway, because if they're going to need to get involved, but
Yeah, I
we're-
think most of the stuff that came to the DRB or the ZBA
yeah,
needed to have
Yeah.
like a lawyer
yeah.
sign off on it and look at it to make sure we were in compliance.
Mhm. Yeah. So as we talked about before, the interested persons are those with the right to appeal the decision, which is the applicant, municipality, property owners and residents that are in the immediate neighborhood. So it doesn't necessarily have to be like an immediate adjoining property owner, but if they're kind of in the general neighborhood. Any petition of 20 persons that are a combination of voters, residents, or property owners. Any department or administrative agency of the state, including the Agency of Commerce and Community Development. The good thing for municipalities is unless you fall into a specific category where you've decided to do on the record review, which Bakersfield does not have, you don't have to make the final decision if someone is an interested person. What is recommended is that when you have everyone sign into the meeting, have them check whether or not they're attending the meeting as an interested person or not. But you don't have to essentially make this determination of do they meet this standard? Because when they appeal to the environmental court will make that determination of if they have the standing to appeal as an interested person. So you want to note whether or not they think they are an interested person, but you don't have to be in the position to say like, actually, we don't think you're an interested person in this proposal. Because what this really matters for is who has the right to appeal.
Can you define an interested person in a bylaw or?
Yeah, and most bylaws do, although some might be outdated because they did make a few changes here and there.
I think we're kind of
Yeah.
probably butters only right now, but
Yeah.
sounds like you could potentially be an interested.
Yeah. Yeah, this is in state statute, so it would override whatever is in the bylaws.
Is there any statute saying that like when somebody puts in a zoning request and it's posted here,
Mhm.
they don't have to post it online for people? They can just post it here and it's okay?
Yeah, and they have to post, like, if you have to post the physical permit poster like on your property visible from the road right of way.
But there's nothing requiring the town to put it on the website.
Not for individual development review, no. You need to put your agendas and your hearing notices on the website, but like not all of the application materials necessarily, although that can be a good practice.
That would be great
Yeah.
because the building is only open 8 to noon, Monday
Yeah.
through Thursday. So you're kind of eliminating a good
Yeah.
portion of and they stack them. It's
Yeah.
not like they're individual. There's like 7 applications in under a pin and you
Yeah.
have to kind of like weed through
Yeah,
them.
I think it's a great practice for public transparency to do that, but the only things that need to go up are the agendas and the hearing notices themselves.
So there's no way we can say you have to.
Yes.
That's what I'm hearing.
Yes. And in terms of the interested persons, it's worth noting that someone doesn't have to necessarily attend in person. They can also send written comments to the development review board before a hearing, for example. So like if someone's not available on the evening of the hearing, they can send written comments, and that also creates participation within the hearing that allows that person to appeal. Because in order to appeal a decision, you have to have participated in the hearing. Basically, the state says, if you didn't care, too bad. No, you don't get to care now.
In India or something, it couldn't physically be.
Yeah, exactly. He could send written comments, like either via letter or via email, that would be considered participation. So the general flow of the hearing, and again, this is set out in your rules of procedure, but the chair will open the hearing. Some towns swear in people when they are presenting on proposals or requests, but it's not necessarily mandatory if you're not an on-the-record review town. The applicant presents the proposal or request. The board members are then able to ask questions in relation to the conformance with those provisions in the land use regulations. There's commenters from interested parties and the public. Again, you don't have to make that distinction. Most towns that don't do on the record review just allow anyone who wants to comment. And then you close once you've heard all of the information that you need, which may not be on that night, that's when you close the hearing. And that's when you then open deliberations. And we'll go into this in a little more detail. And then finally, you decide on the application and issue a written decision. So one of, I think, the biggest mistakes that communities can make is closing the hearing before they have all of the information that they need. So you have a hearing on one night and you still have a bunch of questions, but you think, oh, it's the end of the evening. It's 9 p.m. and we want to leave. We'll close the hearing. But what you actually need to do is continue the hearing, and you can continue the hearing without needing to warn it again, as long as you continue it to a time and place certain, which means you say at that meeting, we're continuing the hearing to, May 26th at 6 p.m. at the Bakersfield town office. And you announce that. The other thing you can do is request a site visit, which allows you to actually observe the site itself. But this can be dangerous because you don't want to ask for testimony or otherwise have like ex parte communication about the project itself outside of the hearing. So you just want to look and state factual information like this is the parcel, this is the edge of the parcel, this is where the structure will be, but not like anything more than that. It should be open to the public, so it should be warned as it's going to happen, and you don't need a quorum to attend. And then it's best practice to, at the next meeting where you have the hearing open, observe who is present, any relevant observations, so that those are added to the official hearing record. So that's another area where it can be really useful, but you can also get yourself in trouble really quickly. So yeah, when you decide to close the hearing, you should think about, do we need to take more evidence? Have we heard enough to make a decision? Are there parties that we need to hear from that weren't able to attend? So you can recess or adjourn until another time or date certain. You can recess or adjourn until a new hearing is warned. So if you can't figure out at that meeting another time and date, then you would need to warn it again as another public hearing. And then finally, when you are ready to adjourn the hearing, you close it. And at that point, you can't take on any new evidence or testimony. So you can't be like, well, wait, we actually need this, that, and this piece of information to make the decision. You have to just make the decision with the information you have at that point. So then you have the deliberation. So after you've closed the hearing, you can deliberate. The deliberations are exempt from the open meeting law. You don't need to have notice and you don't need to take minutes. And they can be done in public, as in front of everyone, or in private. Generally, we recommend that boards deliberate in private, so kick all everyone out to deliberate, because it just makes it easier to have an open and honest discussion amongst the board and get to all the relevant topics, and without having that pressure of the public there. And the last thing you want is if people get in the habit of they're used to you deliberating in public, and then you have a really controversial project and you try to deliberate in private, it creates this appearance that the board's not being transparent rather than it just being the regular process of the board. And this also is important because in your decisions, the decisions simply reflect the majority of the board. So it's not necessary to state who was in favor of the project and who was opposed, for example, if it was a split decision. So those are all ways that I think can just help protect the board's ability to deliberate fairly on the basis of the bylaw without necessarily having, a lot of public pressure in that deliberation stage once everyone's already had the chance to be heard and provide all of the information that needs to be provided.
So you're recommending we should do this for every subdivision hearing, or?
Yeah.
Even like that boundary, just running this movie?
Yeah, is just say, we're gonna deliberate now, send everyone out the door, and the deliberations might be 3 minutes, yes, this project, exactly, yes, this project meets the standards of the bylaw, no one has any concerns, okay, great. And in some cases, you might be able to make the decision that night, but you don't need to. You have 45 days from the close of the hearing to write the decision. So if you've had a controversial project and you've been in the hearing is run for 3 hours and it's like 9:30 at night, and you can say, okay, we're closing the hearing, and then we as the board are gonna go deliberate later. You don't have to do it on the same night, so that's another thing to be aware of.
And we can also ask them to step out
Yep,
and then just go
Yeah, exactly.
and get them.
yep, yeah, you can just say, we're gonna deliberate now, please step out in 5 minutes, we'll probably have made a decision on this, so. It really just depends on how long you think those deliberations are gonna take. But I think, yeah, it's a best practice to just do it that way, because that way, when you do have a controversial project, it isn't like, oh, all of a sudden you're switching up your procedures and
Yeah,
that
looks like you're doing something.
looks like you're doing something shady when it's completely allowed and an intended part of the process. So what should be in your decision? It should be a written decision. Technically, you can use meeting minutes as a decision, but we really don't recommend that. We recommend writing out a specific decision. So the first piece of the decision is the findings of facts. These are the factual basis for the conclusions of the DRB. So you don't need to recite all of the evidence, but you want to state the evidence that is specifically relevant to those factual findings that you're making. And if there's a controversy between two different factual sources of information, you want to make it clear what the DRB believes to be the true factual information about the property. Maybe the applicant said the structure is going to be 30 feet back, but you went to a site visit and the sight line is 25 feet back or something like that. So those are the first pieces, the findings of fact, those factual information. And then you're looking at the conclusions of the law, and that's saying, okay, the finding of fact might be the structure will be set back 30 feet from the road. And the conclusion of law is the setback standard for this district is 25 feet from the road. Therefore, it meets the front setback. So you're looking at each relevant standard in your bylaw. And obviously, it's going to get more complicated when you're looking at something like character of the area. But each relevant standard of your bylaw, and do the facts conform to that standard? And then your decision will say whether the board approved or denied the decision. Again, that's the majority of the board. It doesn't have to note if it was a split decision. And any reasonable conditions or safeguards you're placing in order to meet those bylaw standards. And in some cases, you may require submission of a bond or escrow account. That tends to be, for example, for a subdivision where you're looking at infrastructure that they're going to build or things like that sometimes.
Did you say what AMP was?
Yeah, that's the appropriate municipal panel. So you can mentally replace development review board.
Mhm.
It's just another one of our,
What is it?
it's essentially the development review,
Municipal.
appropriate municipal panel. So it's because essentially that could be in some communities, the zoning board of adjustments, the planning commission, but now with your single model, it's all the development review board. So it's really helpful to have like a template for your decisions that says like, here are the findings of fact, here's where the conclusions of law, here's the decision and conditions. That way, as you're writing it, you're making sure that you catch all of those pieces, because otherwise it's,
VLCT probably has
Yeah.
a template.
yeah, there's some templates. I think I can,
Then you just put it in AI and you can just tell it, ChatGPT.
yeah, as long as you're making sure that you're,
Exactly.
it's not making stuff up.
Oh,
So do, always verify. And this is, you have 45 days from the close of the hearing to do your decision. So it's not need to be done immediately, but you do need to do it within 45 days. Otherwise, on the 46th day, it can be deemed approved without, there is a process that they have to go to the courts to get that deemed approval, but it's best not to let it get to that. Make sure that your decision is issued within 45 days of the close of the hearing.
And who technically has to sign? Just I know it has to have a signature on there.
Yeah, I believe that it's just signed by the members of the board, but it doesn't necessarily, it's not like I approve of this decision. It's just this reflects the majority of the board's opinion.
Okay.
So conflicts of interest, the conflict of interest can be a financial interest, whether that's a direct financial or an indirect financial interest. a personal interest, that's usually like, for example, it's a family member, a spouse, a child, like a close family member, direct or indirect. It's not, any person you know in town, because that would be impossible to manage in the state of Vermont. A known bias or prejudice. So like, if you have been on Facebook for the past 5 years saying, we don't want a Dollar General in this town, and then Dollar General comes, it's probably best to recuse yourself from that hearing, because you've made it like really clear what your position is on that issue. So that can come up sometimes. And then also, we've talked about ex parte communication. So if you have any of those situations come up, it's best to just acknowledge them and recuse yourself if necessary. Yeah, and just maintain the public's trust by trying to be as transparent as possible, so that folks feel like the system is fair. I know.
Recuse myself.
Be a professional recuser.
Yes. Yep, and then just disclose, discuss, determine whether the member needs to recuse themselves, and then record that in the minutes. And so just some additional reminders for protecting due process, which is really important. It's, it's directly related to our constitutional rights, making sure the proper public notice is warned for each hearing. So for both conditional use and site plan review, there's specific standards for those hearings that are in your zoning bylaw that you have to meet, that all people are given the opportunity to be heard, that you hold an orderly proceeding, that you manage, intake all of the evidence and note any conflicts of interest. And we're always here to help. There's also your town attorney and the VLCT municipal assistance attorneys can also be helpful.
RPC is regional plan.
Regional Planning Commission.
I was running it through.
I'm so we've got to reduce the amount of acronyms in this presentation.
I was just thinking that, what is art? And I'm like, oh.
Yes. So I'm going to go into open meeting law specific, but any questions on overall board process and yes. Yep. And then this is an abbreviated open meeting law. So as noted for the chairs of the DRB this is the link to the state of Vermont open meeting law training. And then there's also required ethics training. And that is also linked here. So you'll get the link to that. I think it's like a 15-20 minute like slideshow. And that one you'll actually get at the end of it, like a little like certificate that says I took the ethics training. And so that's also required for quasi judicial bodies like development review boards.
Is there a record of that we've taken the?
Yeah, it will like generate a little PDF for you that you can save. That says like,
Put it on your LinkedIn.
yeah, put it up on the wall. But yeah, it should get it that the open meeting law is just a video. So there's not really any like it doesn't generate anything for you that you did it. So you might want to just note down somewhere on this date. And that one's only required for the chair. But the ethics training is required for all members of the development review board, as well as all members of the select board.
Once a year or just once?
I think it's once upon being added to the board, and then there is some re-up requirement. I think it might be 3 years, but I'll double. I'm not sure. This is
The open meeting law is yearly though.
yeah, the open meeting law is yearly. For those that it applies to. And then also making sure that you have online the your municipal procedures for submitting notice of any open meeting law violations. And a copy of the open meeting law text is required on the website as well, the 1 VSA 314.
She has that on
Yeah.
there. Yeah.
Yeah, so really broadly, the open meeting law requires that there be agendas in advance for public notice of all meetings, that all business and actions are taken in open meeting, as we notice with exceptions like deliberations of the development review board, or things that fall within the executive session exemptions. that members of the public are allowed to attend and participate in meetings, and that meeting minutes are taken and made available to the public. So broadly, for regular meetings, so this is outside of your hearings. Your hearings have set warnings, and they're usually like 15 days or 21 days. But for meetings themselves, so like for a regular planning commission meeting, for example, if it's on the regular meeting date and time that you have an agenda posted 48 hours in advance, you can also do a special meeting that takes place outside of the regular schedule with an agenda posted at least 24 hours in advance. And then in certain select cases, you can do emergency meetings only when necessary for immediate action, and the public notice must be given as soon as possible, as well as notice to local newspapers. Generally, this really only applies for select boards who, need to have an emergency, like a disaster-related emergency meeting, for example. Typically, for most business of a planning commissioner, you can do it with 24 hours notice. Some more of this, if your road is sliding into the river, for example, the select board needs to meet immediately. So your meeting minutes need to have at minimum the names of the members, any active participants, all motions, proposals, and resolutions, and the results of all votes. And they should be available within 5 days, posted on the website and maintained for a period of at least a year on the website and in the town office. For
That when you refer to websites at the town.
that's the town website, yep. So when you are acting within your role as the development review board, that's when you're required to record meetings. So these can be video or audio only recordings, with the exception of site inspections and field visits. So like if you do a site visit, you don't need to record that because the state recognizes that that's technologically impossible for most people. And you need to retain and post those recordings in a designated location for at least 30 days after the posting of minutes, unless doing so would produce an undue hardship on the municipality. So you can, for example, save the recordings to like a platform like YouTube, which will host them for free and then link them on your town website. So that's what we do, for example, at NRPC, because it means we're not paying to host the video itself, which is expensive. But you can put them up on YouTube. If you're an advisory body, so when you're operating as the planning commission, you're considered an advisory body because all final decisions go through the select board, essentially. Like you edit the town plan and the zoning bylaws, but then after your approval, the select board then approves it. You don't directly control your budget. That's sent to you by the select board. As opposed to when you're acting as the development review board, you're considered a non-advisory body because the development review board makes final decisions on development review proposals that don't get reviewed by anyone else at the town level. So when acting within your planning commission function, you don't have the obligation to record. Although you still can if your municipality does.
But if you do record, you have to post it. So it's either don't
Yes.
do.
Yeah, I would say if you did record it, you should post it for 30 days. Yeah.
Okay.
I think that'd be better practice. So what are individual and public rights? They have the right to be able to obtain the agendas in advance and be notified of meetings, to view or copy the minutes and listen to any recordings. They also have the ability to participate in meetings provided that it is reasonable. You are able to limit the amount of time that each person gives for public comment. So for example, you have a lot of people in a limited amount of time, you can request a limit. And also they do not have permission to disturb the lawful assembly or meetings of persons. So if you have someone that is causing a disturbance, you can ask them to step aside. They can also file written notice and a civil suit alleging violations of the open meeting law. And they have the right to attend meetings as well as requesting accommodations if needed. So there should be a process set through in your town of who to contact if someone needs, for example, an accessibility accommodation. An example would be if someone needed like sign language interpreter, there's a set process by which they can request that. Additionally, if you are meeting only in person, or in the case of a planning commission meeting, you are also enabled to meet for planning commission business as only virtually. But the public, which includes any resident in the geographic area of jurisdiction, so any resident of Bakersfield, any member of the public body or a member of the press, can request either a designated physical location for an all virtual meeting, which is allowable for advisory bodies like a planning commission, or electronic or telephone remote access. The request does have to be in writing, but they don't need to give you a reason why, at least 2 or more business days before each meeting. And they must request for each meeting that they want this access. So for example, if your board met only in person and someone wanted access via electronic or telephone, they can't say, can you provide that for every meeting going forward? They have to ask for each meeting individually. And their request must be granted unless there's an emergency incident that's happening or undue hardship. So for example, you can, a board that normally is required to meet in person can switch to electronic only in a designated state of emergency, for example. So like you have a snowstorm and there's a state designated emergency, or a local incident. Or additionally, for example, if in rare and unfortunate cases where there's, for example, a public safety threat that is made related to a meeting, the board can choose to meet, declare that as a safety incident and meet remotely for like a safety reason, for example, which does unfortunately come up once in a while. So it's really important that if someone does formally, that you have a process that someone can formally complain of an open meeting violation, and then you have a process for responding to that. So if once you hear of an open meeting law violation, you have 10 days for the municipality overall to respond publicly. You can either accept the violation, say like, yep, our bad, we did accidentally violate the open meeting law. Usually it's an accident, not on purpose. Or you can say, no, we didn't do that. And if you don't respond, it's considered a denial. So in the case that you publicly accept that there was a violation of the open meeting law, you can state whatever your intent is to cure the violation. So let's say you accidentally forgot to warn a meeting. It would be reviewing all of the discussion, the main points of the discussion, all of the motions that happened at that meeting that you forgot to warn at a upcoming warrant meeting, for example, could cure that violation. Or for example, let's say you accidentally discussed public business in an email of all the board members. Just reading out that email at the start of your next meeting would cure that violation. And adopt any specific measures to prevent future violations. If you deny the violation, you say, no, we didn't actually violate the open meeting law. That is where it creates an eligibility for them to potentially file a civil lawsuit. So generally, if you know you made an honest mistake, the best thing to do is just admit that you made an honest mistake and do your best to cure whatever that violation is, so that that information is now within the public record. And these are also some additional links to the actual text of the meeting law from the Secretary of State's training, and as well as resources available from the Secretary of State about the public records law, which is what we were talking about, the public accommodations requirements, which relates to the Americans with Disabilities Act, and the VLCT open meeting law. Sorry, that's a lot of information that I'm throwing at you. But I will also send you the copy of this, and you know, we are always available. If when you have questions, just shoot us an email or send us a phone call, and we'll make sure we get back to you.
So if somebody wants to meet at a DRB meeting, if they think that they're going to present like a case to us or a
Yeah.
hearing, they want
Yeah.
a hearing, we could do it on the same night as our scheduled.
Yeah, so you could like, let's say you have a hearing, you can warn that hearing for the same evening as your regularly scheduled public meeting. And what you would just have is you would have like your hearing first, probably like, okay, this is our hearing. Then you either are closing your hearing or continuing it to, you know, your time and date certain, your next date that you're gonna address the hearing, and then you're opening the public meeting.
Okay, so it'd
At the
be
end of
two
that.
complete separate meetings.
Yeah, it's like two separate meetings, but they can happen at the same time and date, if that makes sense. But your hearing is that formal DRB review process, and you're saying, okay, we're either, closing this hearing, making a decision, or moving that to an upcoming date to continue it. Now we're gonna do our meeting as the planning commission and do our planning commission business.
We have one coming up in June, right?
Mhm.
Yeah, there's one coming.
Heather told me, yeah.
Yeah.
I don't know what data.
Yeah, and you can even write it within your planning commission agenda, your combined planning commission DRB agenda as the first item is hearing, and so and so. You just need to make sure it also got warned separately as a hearing through the hearing warning process, which is more involved.
Yeah, because that requires a 15 day.
Yeah, it requires that 15-day, and it's getting sent out usually to the abutters and yeah.
I think if I recall
Yeah.
that the zoning administrator is gonna do it for this time.
Yeah.
Because they were asking if we were meeting in June
Yep.
at the last meeting.
Yeah, sending out those hearing.
Good. Hopefully you'll keep doing that.
So we can take information
Yep.
and we just send it out, but we can't discuss it.
Yes, exactly. Yeah, you can.
So that's perfect.
Yeah, the things that you can do via email are like share information. You can even share like, this is the draft that I've written, but you just, other people can't respond to that email. And then you can discuss things like practical matters, like when are we gonna meet? What time works for everyone? When are we gonna have this public outreach session? Like who's available this date, things like that. But you can't discuss anything that would be the business of the board. Yeah.
In times past, did the zoning administrator, were they the ones that sent the notice? And I remember getting packages in the mail at one point saying, this is what an upcoming.
Yeah.
We're going to.
Yeah, this
Does-
zoning administrator should be receiving, in terms of the hearings
Yeah.
related, they should be receiving all of the application materials. At minimum, reviewing them and making sure that it's a complete application, like it has all of the materials required by your zoning bylaw, and then warning the hearing and sending that out to the development if
Yeah.
it needs development review hearing.
Just so we aren't coming inside blinded going.
Yes,
what
yeah.
the heck is this? Like we have a chance to look over the stuff.
Yeah.
Yeah, you should receive that in advance from your zoning administrator once they've deemed that it's complete and they're looking to schedule that hearing.
Okay.
Because you should avoid scheduling the hearing until you at a minimum have all of the information that is required by your zoning bylaw, like have a complete application.
Get that the night of the hearing.
Yeah.
It's kind of.
Yeah.
We get a presentation, so we get.
Yeah.
We can decide.
Yeah. At minimum, you want to have the actual materials themselves sent out to you in advance so you have a chance to look at them.
To look
And
it over and not be like, what the heck is it?
yeah, yeah, that's definitely best. And you can include like within your zoning bylaws the requirements that the applicants, actually provide like 5 physical copies of all of the materials, for example, so that, or some towns just charge the applicant for it, but you can make sure that that cost isn't borne by the town through your fee schedule, either by literally requiring them to have 5 copies or saying part of the fee is paying for copies so that we all have
Yeah, that
information.
makes sense.
Yeah, we do have.
Yeah,
We just gotta get the zoning, the ZA to,
Email the
and
information.
we'll start coming to the meeting.
Yeah, that would be nice. I mean, we did have one ZA once that was pretty regular, so.
Yeah.
Thanks for coming in.
yes,
Yeah, very nice.
thank you. Yep. And if you think of anything like, the next couple of weeks, say you're like, wait, I didn't ask about that, feel free to email as well.
What did, or did Luke say, I don't want to do this?
Oh, we are making, see that? He's got enough
Luke saying, I'm not doing this.
He's got another couple years before we force him to start doing this on his own.
Can we make a motion to end the meeting?
Actually,
Yeah,
we have a full agenda that we should make sure that we're
Darn it.
covering.
Sorry.
So is there any other business that anyone has?
Thank you so much, Emily.
Yeah, thank you.
Yeah.
Thank you. Good travels back.
Thanks, you too.
And so the next to last thing is the next meeting date. So we're in May, and so the meeting in June is what people were referring to a little bit ago, and
Bye, Emily.
that would be June 1st. And is there any problem with June 1st?
For me,
I can make it. All right, so June 1st at 7 would be our next meeting date. And then that's it. If there's no other,
yeah, I'm assuming Luke will send some stuff out that we'll need to
right,
review.
I think he's planning on it being a regular meeting.
Yeah,
Hmm.
it sounds like we might have a hearing that night, so we'll have to kind of fit that in.
I think he'll probably be patient.
Yeah, he's
We
so
want to
nice.
try to handle our hearings first, I think.
Yeah.
We could tell him to be here like a half hour late, because usually a hearing takes about a half hour. don't you
I
think?
would never say usually. I would just say our meeting starts at 7.
Mhm.
And there is a hearing.
Oh, technically it would be two separate, a hearing and a planning commission meeting. So you could have the hearing set for 7 to 7:30. Or not give it a time and then just say the.
I think
starts.
it's difficult until we see the,
Planning commission starts after the hearing or.
Yeah,
I mean, we've seen some photographs of some documents, but we really haven't seen
Mhm.
the drawings and we haven't heard from the applicant.
Yeah,
It would be useful for us to give them the amount of time that would be necessary, and then we could adjourn the DRB hearing and go into the planning commission discussion of the town plan revision. That would be my
Mhm.
suggestion.
so you for sure want to keep it on the same night and not do it on a
I
separate.
do not want to do other nights. I'm
Okay.
already in 4 volunteer committees.
Okay, so I can do agenda for, I think, one more. Yeah.
5 Mondays in June,
So
maybe.
Yeah.
what would I say for the agenda starting for the DRB part?
Hearing.
The hearing would be 7, or do you want to do earlier, 6:30?
I think you can use your agenda that you've used for the planning commission. Just call it the design development review board,
Yeah,
and then have instead of new business being the DRB procedures, it would be this hearing for the applicant if they're ready to actually do that.
and then the other one, what do I put for starting time of the
You can
actual
say,
planning
you
commission?
can,
Completion of the
that's the best way to do it.
Okay,
hearing.
so I would just put like technically 7 PM and then parenthesis after hearing.
Planning
Yes.
commission will meet after.
That way people could be early,
Yeah,
but they won't be late.
right.
Yeah, I move we adjourn this meeting.
All right, so at
I second.
9:30, we will adjourn the meeting.
30.
Yeah, 2.5 hours.
Yeah. It was.
Zoning.
That might have been a record long one.
It was jam packed. What are you talking about,
It
Ken?
was, I mean, it was good to hear all that stuff again. I mean, a lot of that was. Obviously, aimed at bigger municipalities.